Hello everyone. Today we are starting unit 2 of contract 2 and our first topic is bailment. Now many students think bailment is a difficult concept, but actually we deal with bailment in everyday life. For example, suppose your bike breaks down and you leave it with a mechanic for repair. Now think about it. Has the ownership of the bike changed? No. The bike still belongs to you. The mechanic has only received possession of a specific purpose. And this is exactly what bailment is. According to section 148 of Indian Contract Act, bailment means the delivery of goods by one person to another for a specific purpose, with a condition that after the purpose is completed, the goods will be returned. Now don't try to memorize the entire definition. Just remember three words: delivery, purpose, and return. If these three things are present, there is usually a bailment. The person who delivers the good is called the bailor. The person who receives the goods is called the bailee. A simple trick is bailor gives, bailee receives. Now let's understand the essentials of bailment. The first essential is delivery of goods. Without delivery, there can be no bailment. The second essential is a specific purpose. For example, repair, transportation, storage, safe custody. The third essential is return of goods. After the purpose is completed, the goods must be returned. This is one of the most important features of bailment. Now here is a very important point for examinations. In bailment, ownership never changes. Only possession changes. Remember this line because it can be used directly in answer writing. Ownership remains with the bailor. Possession goes to the bailee. Now let's look at an important case law. Coggs versus Bernard. This case is considered one of the foundation of the bailment law. The facts were simple. A person agreed to transport goods for another person without charging any money. While transporting the goods, he acted carelessly and the goods were damaged. His defense was very simple. He said, "I was doing it for free, so I should not be liable." But the court disagreed. The court held that once a person takes possession of goods, he has a duty to take reasonable care of them, even if no payment is being made. The principle from this case can be remembered in one line. Free service does not mean free negligence. And this principle later became very important in understanding the duties of a bailee. Before ending, let's quickly revise section 148 bailment. Three keywords: delivery, purpose, return. Two parties: bailor, bailee. One important principle: ownership does not transfer, only possession transfers. And one important case: Coggs versus Bernard. Free service does not mean free negligence. In the next part, we will discuss the duties and rights of bailor and bailee. which are frequently asked in examinations. Thank you and all the best for your contract 2 preparation.